Bailment is formed by the delivery of personal property without transfer of title by one person to another person, a bailee, usually under an agreement for a particular purpose. So, example, having somebody hold your luggage while you're on a plane, dropping your clothes off at the dry cleaner. The property must be returned by the bailee to the bailor or to some third party as directed by the bailor in the same or better condition. It's established when personal property, tangible or intangible, is delivered to the bailee, giving them exclusive control or possession. And again, it might be actual or constructive. And the bailee must knowingly accept a bailment. In some cases, there could be an involuntary bailment when, like for example, a locker's provided for that purpose. So even though the bailee doesn't know they have possession of it, it's considered a bailment. There are bailments for the sole benefit of the bailor, sole benefit of the bailee, and mutual benefit bailments. Another word for sole benefit of bailor bailments would be a gratuitous bailment, where the bailee owes the bailor a low duty of care. They're only liable for gross negligence. If it's for the sole benefit of the bailee, the one who's holding it, for example, borrowing a car, they owe the bailor a high duty of care, and they're liable for even slight negligence. And mutual benefit, where it benefits both parties, example would be dropping your car off for repairs, where you pay the shop. Each party owes the other a reasonable duty of care. Rights and duties of the bailor and the bailee. A bailee has the right to possess the property temporarily, even though title doesn't pass, to use it if that's part of the agreement, to be compensated or reimbursed, and to limit their liability. They have a duty to return the bailed property in the same condition or be liable for conversion or negligence. The bailor, if they're going to let somebody hold on to their property, has a duty to reveal defects. If it's a mutual benefit bailment, they must notify the bailee of any defects the bailor knows of or could have reasonably discovered. If it's for the bailee's benefit, only known defects. Other examples of bailments: common carriers, warehouses, hotels. Common carriers are strictly liable for damages unless there's some statutory example or exemption. A warehouse is basically some place that holds property that belongs to someone else. There's usually some documents that evidence title, and they typically, because it's a mutual benefit bailment, owe a reasonable duty of care. They can't eliminate their own negligence from liability, but they can limit it. And hotels, those are often controlled by statutes. Insurance is a contract. It's specifically to transfer and allocate risk, usually classified according to the type of risk, for example, fire, casualty, life, title. Risk is a prediction concerning potential loss based on known and unknown factors. Risk management would be management of those risks. Policy is a contract. Premium is a consideration. Underwriter is somebody who determines that risk, and that's usually an insurance company. And typically, there's a difference between a broker and an agent. Agent is usually acting on your behalf. A broker is usually somebody who is, and in that case, often an insurance company has agents that work for them, and a broker would be potentially multiple types of insurance, or even representing somebody who's looking for insurance. Insurance contracts are governed by the general principles of contract law, regulated by state. The application is considered part of the contract. It's initially an offer that the company could accept or reject. Needs consideration. Parties need legal capacity. When it's filled in and accepted, it becomes part of the contract. And a misstatement or misrepresentation could cause the contract to become void. It could be An effective date that varies depending on the agreement of the party. In the case of a broker, they're an agent for the applicant. An agent is typically an agent for the insurance company, so they can issue a binder if there's some consideration that's paid. There's different clauses listed in your chapter. A couple examples are the coinsurance clause. If somebody were to insure their property for at least 80% of its value, the owner will be able to recover up to the face value of the policy. For less than 80%, they would be responsible for a proportionate share of the loss. In contestability clause, after a period of time, the insurance company wouldn't be able to contest the original application for insurance. Typically, the courts interpret ambiguity in insurance contracts against the insurance company because they wrote the contract. Insurers need to notify the insured there's going to be a change to the policy. Insured can cancel the contract at any time. Insurers typically have terms limiting their ability to cancel the insurance. Usually they need to give some kind of written notice of cancellation. They have good faith obligations in terms of investigating, defending, acting in good faith. Insurance companies often raise defenses against payment, which would include fraud or misrepresentation, or concurrent causation, arguing that something else caused the damage, which is not covered under the insurance policy.